In Canadian news this week, Redux has reported that a self-described kink-allied psychologist who worked with vulnerable youth in Calgary is now facing child pornography charges. 45-year-old Dustin Reichen was arrested on January 30th by the Alberta Law Enforcement Response Team, or ALERT's, Internet Child Exploitation Unit. Reichen has been charged with possessing and disseminating child pornography through the online social media application Kik. A now-deleted online profile posted to Psychology Today listed Reichen as a sex-positive, kink-allied, queer-allied, transgender-allied, and non-monogamy expert offering counseling services to teens and adults. It is unclear at this time whether any of his adolescent patients were subjected to his abuse and exploitation. In other news, Redux also revealed this week that trans-identified man Nathaniel Morin, who is advisor to the Minister of Women and Gender Equality, Marcy Ian, and who claimed on X that trans-identified men do not have an advantage over women in sports, had previously dominated while running in the women's category in a 5-kilometer race. Morin took to social media last week in response to President Trump's executive order protecting women and girls in sport, sharing infographics made by another trans-identified man who also competes in the women's category in sports, stating that, quote, trans women do not have an advantage and biological diversity is everywhere. It's interesting that Morin would post such a clownish take, especially considering that in February of 2024, he competed in a women's 5K in Ottawa, finishing a whopping 5 minutes and 44 seconds ahead of the female who was awarded second place. Finally, I attended the CCOHR, or Continuing Committee of Officials on Human Rights meeting on CEDAW last Thursday. As I mentioned last week, they disabled the chat and were only allowing questions to be asked through the Q&A tab. I posted the following question because there were several women present who are meant to be advocating for the rights of Canadian women and girls. It has been reported that a trans-identifying male has been charged with sexually assaulting at least 4 women at a women's shelter in Edmonton in August. Considering the fact that this is not the first or even second time this has happened due to self-identification policies, is there any consideration being given to finding a solution that protects women from predatory males taking advantage of self-ID? At this time, the only female-only rape relief center in Canada is Vancouver Rape Relief, and they have had their government funding pulled as a result of the center accommodating females exclusively. It is crucial for many traumatized women to be assured that they will be treated by and housed with females. Is there anyone in a position to advocate for women and girls, taking into consideration the needs of these women? This question was asked by Dr. Hacker at Canada's CEDAW appearance, but was ignored. Every single question asked in the Q&A that day was answered except for mine. And I think that speaks volumes to the selective advocacy displayed by the supposed feminist organizations funded by the Canadian government. There was a representative from Wage there who, of course, had no answers for me. But I will continue to attend these meetings because I think it's important that these people know that WDI is here and we're paying attention. And I also think that it's valuable to pass on information to these people that the mainstream media is not covering. I think these are the people who need to hear this information the most.
As you may have noticed, events here in the US have been transpiring quickly. Try as I might to limit the length of my briefings, doing so is often impossible with so much going on, and I apologize in advance for the length of today's report. I'll begin by sharing that the recording of our recent webinar, How the Trans Lobby Co-opted the Struggle for Black American Civil Rights, is now available on WDI USA's YouTube channel. Moving on, the biggest news rocking our world this week is that on February 5th, National Girls and Women's in Sports Day, President Trump signed an executive order titled Keeping Men Out of Women's Sports. In Section 1, Policy and Purpose, the order declares it is the policy of the U.S. to rescind all funds from educational programs that deprive women and girls of fair athletic opportunities, which results in the endangerment, humiliation, and silencing of women and girls and deprives them of privacy. It shall also be the policy of the U.S. to oppose male competitive participation in women's sports more broadly as a matter of safety, fairness, dignity, and truth. Section 3A directs the Secretary of Education to take all appropriate action to affirmatively protect all female athletic opportunities and all female locker rooms, and to prioritize, Title IX enforcement actions against institutions, including athletic associations, that deny female students an equal opportunity to participate in sports and athletic events. Section 3B states that all executive departments and agencies shall review grants to educational programs and, where appropriate, rescind funding to those that fail to comply with the order. And 3C, that the Department of Justice shall provide all necessary resources to relevant agencies to ensure expeditious enforcement. Section 4A directs the Assistant to the President for Domestic Policy to convene representatives of major athletic organizations and governing bodies and female athletes harmed by such policies to promote those that are fair and safe in the best interest of female athletes and consistent with Title IX, and to convene state attorneys general to identify best practices for women as well. Section 4B and C directs the Secretaries of State and Homeland Security to take various actions, including at the UN, to protect the sex-based female sports category internationally. At the White House signing ceremony, Trump said that his administration will not stand by and watch men beat and batter female athletes at the 2028 Summer Games set to take place in Los Angeles, and that he's directed Secretary of Homeland Security Kristi Noem to deny any and all visa applications submitted by male athletes who identify as women to fraudulently enter the U.S. to try and get into the games. Right out of the gate, the U.S. Department of Education got busy with the aforementioned enforcement actions with its announcements that the department's Office of Civil Rights, OCR, is launching directed investigations into San Jose State University, the University of Pennsylvania, and the Massachusetts Interscholastic Athletic Association for apparent Title IX violations. Additionally, OCR is actively reviewing athletic participation policies at a number of schools to evaluate their alignment with Title IX protections for female athletes. On February 5th, Icons issued a press release announcing that 3 former UPenn swimmers have filed a new lawsuit against the NCAA, Ivy League Conference, and Harvard University, citing harassment, abuse, and federal law violations resulting from the NCAA and Ivy League's decision to allow male swimmer Leah Will Thomas to compete on the UPenn women's team and access women's locker rooms during the 2021 and 2022 season. The suit, backed and supported by Icons on behalf of Grace Estabrook, Ellen Holmquist, and Margot Kazrowski, claims that the NCAA and Ivy League fostered a culture of intimidation while forcing young women to deny biological reality, jeopardizing their opportunities, privacy, and safety in violation of Title IX. Encouragingly, on the same day, NCAA President Charlie Barker issued a statement saying that the Board of Governors would be reviewing the executive order and will take necessary steps to align NCAA policy, and proceeded to announce its new transgender student athlete participation policy on February 6th. Unfortunately, while the policy is a step in the right direction, it is by no means one that comprehensively protects women. For one, it uses ideological rather than biological language, such as a student athlete assigned to male at birth may not compete on a women's team, but does not address how male athletes with a DSD, such as Iman Khalif, who were erroneously assigned female at birth, will be classified. Secondly, it allows males to practice on the team consistent with their gender identity and receive all other benefits applicable to student athletes, which could direct limited resources away from eligible females. The policy also fails to address what locker rooms such males would have access to, nor does it mention whether or not female athletes would be informed should their practices include men. Perhaps most alarmingly, the press release issued by the NCAA about the change includes the statement that individual schools have the autonomy to determine athletics participation on their campuses, which may very well allow for a sanctuary university position. So yeah, while welcome, the new policy needs work. As I mentioned last week, hospitals coast to coast have reportedly taken action to avoid threatened sanctions and loss of federal funds by suspending so-called gender-affirming care for clients under the age of 19. Closer to home for me, that includes Children's Hospital of Wisconsin, which initially began to cancel its gender health clinic appointments, but has since resumed them after a group of families and doctors filed suit backed by the ACLU against the Trump administration, claiming that his EOs defending women and protecting children are unlawful and unconstitutional. At least two state attorneys general, Letitia James in New York and Rob Bonta in California, have issued letters warning hospitals that withholding such care would be a violation of their respective states' anti-discrimination laws. Additionally, a coalition of 15 state AGs, including Wisconsin's Josh Kaul, recently issued a joint statement that denounced Trump's order as wrong on the science and the law, asserts that a recent court order affirmed that the Trump administration cannot halt funding through administrative memos or executive orders, threatened further legal action if the administration continues to impede this critical funding, and reiterated their commitment to enforce state laws. In a Substack published yesterday, Kara mentions another lawsuit filed on the 7th by 3 attorneys general from the blue states of Washington, Oregon, and Minnesota, along with 3 anonymous doctors against the Trump administration's Protecting Children EO, which halts federal funding for the medicalization of minors. Kara's post points to an X thread by attorney Glenna Goldis eviscerating the complaint, which is well worth a review. And finally, also on the 7th, Wolf published news that federal district courts in Boston and DC have issued temporary restraining orders preventing the transfer of male federal Bureau of Prison inmates who claim a woman identity to male prisons in response to separate complaints alleging Trump's defending women EO is unconstitutional because it violates the provision against cruel or unusual punishment. As always, women's needs were not considered in these decisions. And that's all I have today. Thank you.
Suspended because she's the nurse who was suspended because she asked a male doctor who was in the changing room to leave. Or actually, I don't think she even asked him to leave. She told him that he made her uncomfortable, and he then complained about her, and she was suspended. And although I think she then went back to work for a while, she has taken an employment tribunal case against the health board and has named him as the second respondent. And I was up in Dundee. I finally managed to get up there today. The case is being heard in Dundee instead of Edinburgh. And he's just comes over as the most self-absorbed, I mean, this won't come as a surprise, I'm sure, but the most self-absorbed, narcissistic man. He's very, very manipulative as well. So he was always trying to get the better of Naomi Cunningham, who's Sandy's barrister. And I think, you know, maybe his attitude was summed up because when she put to him, well, you know, if a woman, she was just talking about a hypothetical woman, you know, if a woman, say with heavy menstrual bleeding or heavy bleeding or something, came into A&E, because he's an A&E doctor, and asked to see a female doctor, do you think it would be acceptable to have you assigned to her? And he said, yes, that would be absolutely fine, because if she wasn't happy with me, she could tell me. And I mean, I would never want to, you know, look after somebody who wasn't happy about it, and I would go and get a different doctor for her. And didn't seem to have any notion that this would not be really the right way to do it, because, you know, women in that situation aren't often very confident to challenge a doctor that's supposed to be seeing them and treating them. But he was completely convinced that women don't know that he's a man. He kept insisting that he, you know, he doesn't use the word passes, but he kept insisting that nobody realizes that his trans history, and everybody thinks he's a woman. So I don't think he really believed that this hypothetical woman would know who he was. And when he was pressed a little bit further on it, he said, well, yes, you know, because if that wasn't the right way to do it, then the only alternative would be that, you know, he or whoever would, every time they met a patient, would have to introduce themselves, not just with their name, but with their gender identity and their sexuality, and ask if she was comfortable being seen by them, which is ridiculous, because, of course, if you just give a woman doctor when she's asked for it, that's all that's necessary. So there wasn't actually the hearing only went on really this morning. Last Friday, it became apparent that Fife Health Board had failed to produce a lot of documents that they were supposed to produce. Sandy had been, this case is partly about the investigation that they carried out into her. And it transpired on Friday that there had actually been a previous investigation, which it looks like somebody concluded that her suspension was disproportionate, and the female changing rooms should be made female again, or that there was some suggestion of that. Anyway, I'm not quite clear what the status of that document was, but that was all not mentioned. That was never produced. So Friday was completely lost to the hearing while there was all this discussion about paperwork. And then today, something that Upton, the doctor, said made it clear that there's more paperwork that hasn't been produced that should have done, an email trail that emails between himself and the British Medical Association. So again, the whole hearing was stopped while those emails had to be produced, and then there was at least 20 pages of emails, and so the afternoon hearing didn't go ahead. And it was very interesting because there's one barrister for Fife and Upton. Apparently that's not uncommon when the employer supports the second respondent, but anyway, there's only one barrister involved, and she's obviously very keen that none of this is investigated. And she was saying, you know, the thing is, you know, Naomi Cunningham's trying to find a smoking gun and she'll never find one, which does really rather raise the possibility that there is indeed one to be found. But I mean, we don't know for a fact. You know, if and when all the paperwork is finally produced, then, you know, we might get to the bottom of it. I've been fascinated by the extent to which Naomi's had to be acting really as a detective as much as a barrister, because there's just, they found little crumbs. They would be in a paper, there was some comment made that they couldn't make sense of, and when they looked, they realized it must mean that there was some other paper that they hadn't seen, and then they would ask for that, and then there was another crumb and another crumb. So it's been a big bit of detective work. So the result is the hearing was set to last 2 weeks, so it should finish on this Friday, but because of all these delays, and also because it means that there's more questions to be put, in fact, what's going to happen is it won't finish this week. They'll hear a couple more witnesses this week, and then there'll have to be an adjournment until a time, which could be certainly weeks and possibly even months away, before they can find a time that everybody can manage, which is, you know, very unsatisfactory, I think, for everybody. concerned. So there certainly won't be a decision in that case anytime soon. I think one thing that was interesting today was in the Westminster Parliament, Rosie Duffield asked the minister whether she thought it was appropriate for the NHS to expect their female staff to undress in front of men in changing rooms, or words to that effect. And the minister stood up and said no and sat down again. So that suggests that maybe they're aware of this case, and maybe they realize that, you know, it's not really playing out very well. It does look as if this case is piquing quite a lot of people. You see the reporting in the media has a different tone than it's had in the past, which I think is all very good. The other thing that Shirley, my colleague from WDI, who was also at the hearing today with me, drew my attention to, which I hadn't known about, is that Fife NHS have a toolkit for their staff writing equality impact assessments. And in that, there's a chart which lists, you know, the protected characteristics which are under the Equality Act, which they correctly list. And then the sort of second column is, you know, the people who should be targeted for equality action, I suppose. So you have men and women, and then you have minority ethnic groups, and you have disabled people and gay men and lesbian people. So I can only assume that they must have had Mr. Upton in mind, because, you know, he's married to a woman, so he presumably considers himself a lesbian, although that hasn't been discussed in court. So that's just I mean, it's a bit silly, really. I think wearing my lesbian persistence hat, we might write to Fife Health Board and complain about the fact that we've been reduced to people rather than women. Obviously, that's supposed to be an all-encompassing category. So I think that's all I've got for now.
There's a number of legislative proposals in the books in New Zealand at the moment, which affect women's sex-based rights. And one of them is the Stalking and Harassment Bill. And submissions are due for that actually tomorrow. So that's sort of fairly urgent for anyone who in New Zealand listening to this that wants to make a submission. And I imagine that a number of gender critical feminists have made submissions, and including the Women's Rights Party. And the Women's Rights Party submission is now on their website, and I'll post a link to that in the comments. So this bill looks good at first sight, because of who wouldn't want to protect women from stalking and harassment? And that's a good aim. However, the wording is so vague that a woman who objects to a man in her space or doesn't affirm his gender identity could be prosecuted for so-called stalking and harassment if she does it more than once, says he's a man. The Women's Rights Party is calling for the wording to be more specific, and for the real risk of violence and or serious impediment to a woman's daily life should be included in the definition of stalking. Now, another bill which is on the cards is called the Pai-Ora Healthy Futures 3-Day Postnatal Stay Amendment Bill. Now, this also has good intentions, which is to ensure that women get at least 3 days in a hospital if they give birth in hospital to be cared for afterwards, because at the moment many are having to go home very quickly after giving birth, simply because there aren't enough beds or people there to care for them. So it's a good aim. However, there are many factors where this is not quite as good as it looks. The Women's Rights Party have also put a submission in about this. They support the intention to guarantee care for women, but say that more support is needed at home as well. Also, more resources should be put into primary care, such as birthing units. Staying in hospital is not always the best option, especially when the New Zealand maternity hospitals are under-resourced. And women often, simply get moved out from where they gave birth. And if they give birth in an actual public hospital, they often, after birth, get moved to a primary care unit. which would have been, many of them could have been in the primary care unit in the first place. That's like a birthing centre. That's that piece of legislation. Now, another piece is the mental health bill, which the Women's Rights Party made a submission to this in December last year, and today they are presenting an oral submission, which will eventually be up on the parliamentary submissions website. And again, the party agrees with the intention of the bill, which is to reduce coercive practices towards mental health patients, especially those in compulsory treatment, and to give patients more autonomy and choices. But the party disagrees with some of the language, the use of the word gender and gender identity instead of sex, and the word sexual preferences instead of sexual orientation. The bill states that a person cannot be deemed to have a serious mental illness on the grounds of, quote, gender identity or, quote, sexual preferences alone. However, the term sexual preferences could include fetishes and paraphilias, which sometimes are forms of mental illness or even may involve criminal activity. Using the term sexual orientation instead would affirm and support the rights of lesbian, bisexual and gay patients who are probably meant to be included under that term in the bill, but not actually specifically named. So the bill also says that a mental health tribunal, which makes decisions about what happens to the patients, should co-opt someone of the same, quote, gender identity as the patient. The Women's Rights Party says that this should be someone of the same sex. They should use the word sex there, not gender identity. So the party calls for clear factual language and to use the terms sex and sexual orientation. The submission has been submitted and it's been posted online, so I'll show you a link to that. And this is a lot of news from the Women's Rights Party, I know, because this is what I'm aware of is going on right now. I'm sure the other gender critical groups are probably doing other things, but it hasn't sort of reached the public eye yet. So there's the Law Commission is going to meet with the Women's Rights Party. And I'm sure they will be meeting with Speak Up for Women as well regarding proposed hate crime legislation. So there's a bit more time to submit to that. The submissions close on the 13th of March. And I said last time that we need to look at that with a fine-tooth comb because we know how the concepts of hate crime and hate speech can be twisted around against women who say that a man is not a woman. However, there are some good elements in this bill, so I will get back to you about that when we have developed our submission about it. And also the Women's Rights Party has been invited to meet a representative from the Human Rights Commission. They wrote last year when they liked some work that a Pacifica commissioner had done at an international meeting. She's no longer working there, but the Women's Rights Party have been invited to speak to a commissioner, and they're hoping to speak with Stephen Rainbow, who is the new Human Rights Commissioner. Now, he is a gay man and he's the son of a gender-critical feminist and lesbian, Jill Abigail. He did previously, before being appointed, warn in the gay community against conflating trans issues with gay issues. So that looks quite promising, but he has to be, I think, as a Human Rights Commissioner, a bit careful what he says now. So but we would like to talk to him. So see if we can get the Human Rights Commission in general to change its stance, because in general it has been very pro-gender, and it also has a lot of stuff on its website which actually gives misinformation about our current laws, for example, about births, deaths and marriages legislation, and whether, because in fact in that law, the birth certificate, it's admitted that the birth certificate is not an actual proof of someone's sex, whereas the Human Rights Commission website gives the impression that it can be seen that way. So we need to talk with them about all that. And lastly, I just want to mention a woman called Jackie Scott, who I've just read, she died today. and that's very sad news. She was one of the first women to raise awareness of the harms of pelvic mesh in New Zealand. She was a rape survivor, and she suffered greatly for many years from mesh and ceaselessly campaigned against it. So several years ago, she was trying to get the Accident Compensation Commission, which is something we have in New Zealand. We call it ACC for short, and it helps provide funding for people to have treatments after they've experienced accidents or assaults. And she asked them to help her with funding to go to the United States to get the mesh removed, because there's nobody in New Zealand who had the skills to remove it. But they refused. However, she did eventually manage to get there by doing online fundraising. But even after getting it removed, she continued to suffer a lot from the effects of the mesh. And anyway, unfortunately, now she has died. And I regard her as a pioneer for women's health in New Zealand. And after she raised the issue, there was a whole campaign that built up against the mesh. And there is currently a pause of the use of mesh in New Zealand. So that's all today. Thank you.
Because it's not a legal filing or a public hearing, but there are reports that 2 ACT-based psychologists have received complaints from the ACT Human Rights Commission accusing them of conducting conversion therapy because they provide exploratory therapy to youth diagnosed with gender dysphoria rather than just affirming them. If these complaints have been made, the Commission will investigate and private conciliation may be held. If lawsuits are filed, they would be some of the first conversion therapy in lawsuits in Australia. They could be either criminal or civil because the Act provides for both. So we'll see if there's more information on that. In June last year, the Australian E-Safety Commissioner had a tweet by an Australian woman, Celine, geo-blocked in Australia. The tweet was about the existence of a queer club in a primary school. Celine questioned whether this was appropriate for primary-aged children. She contacted the Free Speech Union and they filed an appeal against the takedown notice. The Commissioner argued that they had only issued an informal notice and it therefore couldn't be legally challenged. On the 6th of February, just gone, the Administrative Review Tribunal found that these notices could be reviewed and expressed concern with the practice of sending complaint alerts rather than formal removal notices, because notices give reasons while alerts do not. Justice Kiru found that the alerts deprived users of one of the features of balance that the law strikes between the community's right to free speech and its right to be protected from cyber abuse material. Also on the 6th of February, the Federal Parliament passed its hate speech amendments, with the Senate only taking 5 minutes to pass the bill, 41 in favour, 6 against. The new law expands hate speech to cover grounds including gender identity, intersex status, sexual orientation, and political opinion, and includes mandatory imprisonment for offences involving displaying Nazi symbolism or symbols of recognised terrorist organisations. The law makes it a hate crime offence to threaten force or violence against a group or member of a group, or incite or advocate someone else to, if a reasonable member of the target group would fear the threat would be carried out. So interestingly, the law could cut multiple ways, as lesbians and feminists, for instance, also ought to be protected from threats. Kiralee Smith, co-founder of the advocacy group Binary Australia, is currently in the Sydney local court on a claim of vilification. I think she said it was her 8th court appearance in relation to a range of different claims made against her. This one was brought by a New South Wales man, Stephanie Blanche, a man who claims a transgender identity, and was used by Kiralee as an example of a man playing in women's sports. Kiralee is arguing the constitutional freedom of political communication as part of her defence, which meant that the tribunal lacked jurisdiction and the matter was removed to a court. She was cross-examined last week by Blanche's lawyers, and questions included things like, you don't care how the plaintiff feels or care about her? Don't you think it's unreasonable, no matter what he says, you will always refer to her as he or him? So you don't believe men can become women? I put it to you, women can have Adam's apples. Did you consider she was living as a woman? And did you use the plaintiff's dead name? The decision is due on the 7th of May, and Kirralie is back in court on the 14th of April on a similar matter brought by another man, Riley Dennis, who also plays on women's teams and has been used by Kirralie as an example of that policy. On the 30th of January, the Federal Sex Discrimination Commissioner, Anna Cody, issued a statement criticising the Queensland Government's decision to pause Tanner Stage 1 and 2 interventions on children until an independent review is conducted. So this would just be in the state of Queensland. She described these interventions as a fundamental human right that children would be denied, and warned that restricting access would cause trauma to children. She said that the Australian Human Rights Commission would be contacting the Queensland Government with their concerns. On the 30th of January also, a letter was published from doctors, lawyers, politicians, child psychiatrists and campaigners to the federal government, calling on them to launch an inquiry into puberty blockers and to halt interventions while the review was underway. On the 31st of January, so the day after the letter and 3 days after the Queensland announcement, the federal Labor government did announce an overhaul of the national guidelines for childhood medical interventions based on gender. The national guidelines are influential on the states, but the states control the actual laws in the area. The federal health minister said that this expert committee would include people with lived experience and that it would work with trans organisations. He said the interim guidelines would be due in 2026, with no pause on interventions during that time. And the minister said that since the national review should take precedence, Queensland should halt its own inquiry in favour of the federal one and resume giving Tanner Stage 1 and 2 interventions. Queensland did not agree with that. It is going ahead with its inquiry and its pause on interventions. Organisations, interestingly, including Equality Australia, AusPath, Transcend Australia and LGBTIQ plus Health Australia are supporting the federal government's review. They are not supporting the Queensland one. And lastly, on the 10th of February, One Nation MP Pauline Hanson moved again in the Senate for an independent federal review into childhood gender interventions. This is her last opportunity before the federal election this year. She moved that it be referred to the Community Affairs References Committee for inquiry and report by the 26th of March this year, and it was voted down again, but this time 36 to 21, so a closer margin. Thank you very much.